Good morning.
Start by just reminding us why exactly you're asking for another judicial review.
Okay, here's what this is all about. The Federal Review Panel, which reviewed the new prosperity proposal, failed in their duty to deliver a fair process. And the consequence of their failure resulted in the Federal Minister of Environment making the wrong decision. So what we are seeking is to rectify both of those situations in a court of law, which is the only reasonable option that's open to us at this time.
The detail that I think that has been brought up several times was that the wrong design for the tailings pond was used in the review. Is that correct?
That's correct. The original plan for prosperity was to drain Fish Lake, and that was approved by the province of British Columbia, but not by the federal government. But the federal government said if we could address the concerns that they had, which was the draining of the lake, and bring forward another design, they would review it. And that's what we did. So we committed an additional $300 million to build the mine in a different configuration and thereby save Fish Lake. But that project was also turned down because the process itself was unfair, in our opinion, and the results were flawed as a result, and the wrong decision was made.
So why do you think that the evidence and the process was flawed? I mean, how could some of these major details be overlooked?
Yeah, that's a good question. Natural Resources Canada modeled a different design. The design that we put forward for the tailings pond, which is a big pond, imagine that, that you were constructing one in your backyard. The first thing you would do would be prepare the bottom of that pond so that it would hold water. You would engineer it, and that's what we put forward, an engineered bottom to the tailings pond. But NRCan, for whatever reason, applied a model to a different design that they did not have an engineered bottom on the pond, just a natural bottom as it exists. And so they came up with far different rates of seepage through the bottom of that pond naturally. So how they missed it, why they missed it, we don't know. We want to get to the bottom of that. We want a court to take a look at all of this process, the mistake that was made, the process that was unfolded. Is it consistent with the law? Was the law applied appropriately? Was administrative fairness given to us in that process? We don't think it was. Those are the matters that are being challenged. This is a very serious situation. There are billions of dollars of investment opportunity that are in play here, the potential for thousands of jobs that are needed in the Cariboo. Our system of governance here in British Columbia and in Canada depends on accurate application of the law and fair treatment under the law.
But if this process is flawed, what would be the motives of the Federal Review Panel on First Nations?
The motive of the Federal Review Panel?
What would be the motive if the process is flawed? You say it's been repeatedly done incorrectly, the research hasn't been gathered correctly or analyzed correctly. So why?
Either a poor understanding of the law, an inaccurate application of the law, and the conduct of the panel review process itself was not fair. And we cite several examples of that in the judicial review that we filed yesterday in court.
Now, I also understand that there has been some sort of consultation between First Nations and the review panel that Taseko was not invited in on. Is that correct?
That's part of the unfairness, is that when you go through a process like that, a proponent is to be given every opportunity to respond to any material that may come forward. In this case, the panel process ran its course. The report was then written and delivered to the minister and made public. During that period, though, before the minister and the Government of Canada made a decision, they held meetings with various opponents of the project and did not give us an opportunity to understand what was said at those meetings or the opportunity to respond to what was said at those meetings. And that's fundamentally unfair, and that's part of this lawsuit.
All right. We have a clip here I'd like you to listen to. This is from Silcoteen Chief Joe Alphonse. Stand by.
We have limited resources, and we have to be very selective on when and where we can go to make lobby efforts, and I think they as a company should accept that decision and pack up their tent and move their interests out of Chilcotin territory.
So Chief Joe Alphonse says he'd just like to see Taseko move elsewhere. How can this mine go ahead without the support or the trust of some of the local First Nations?
The situation that currently exists is not about the First Nations. This is a matter between the federal government and Taseko, and it's a matter about whether or not the process was fair. So, Mr. Alphonse is certainly welcome to his opinion, and he's opposed to the project, and we know that. But this matter is between the federal government and Taseko, and it's around the fair application of the law and fair treatment under the law.
What will happen if the federal court agrees with your claims?
We're asking the court to do four things. The first thing is to quash the decisions made by the minister regarding the adverse environmental effects, number one. Number two, an order quashing the decision by the Cabinet of Canada that likely environmental effects are not justified. The third thing we're asking the court to do is to refer the decision back to Cabinet for reconsideration in accordance with the directions of the court. And the fourth thing we're asking for is a declaration that certain sections of the Canadian Environmental Assessment Act 2012 are unconstitutional and thus of no force and effect.
All right. Brian, thanks for explaining things to us.
You're welcome.
Bye-bye.
Bye-bye.